then new contract comes into place and we will work on the new contract. Able to understand? Alteration, whether the old contract will still be continuing or discharged. So it is continuing in nature. We are not replacing any new contract. Old contract, but still we are making minor changes to the contract. Able to understand? Yes, start reading. Start reading. The parties to a contract may substitute. No, this substitute is the keyword. The substitute is a keyword. May substitute a new contract for the contract is discharged and need not be. Novation can be between the same parties or between different parties. The consideration mutually being discharged. Now, when I say novation, old contract straight away goes into the dustbin. Okay. And in place of the old contract, I am going to bring a new contract in place. Now, for this new contract, the law says you can have the same parties or it can be new parties coming in, existing parties going out also. Able to understand? What happens to the old one? Straight to the dustbin, which means it is discharged in nature. Able to understand? Now, this line, come to this line. The consideration being mutual discharge of the old contract. Now, what is this? In place of the old one, new contract is being created. Correct? Now, for us to come and enter into this new contract, what is the consideration of Dina? Discharging the. Able to understand? Okay. Now, we both come together and mutually decide that. Let us give away with this old one and let us take the one. That will be the consideration for you. Clear? Say for example, in the old contract, the contract was between A and B. Okay. Now, in place of this new contract, multiple option is there. A and B irukla. A, B, C, new party can come in. Sir, B wants to go out, A and C can come in, A and C can continue. And the it can be between the same parties or different parties also. Next one, effect of recession. Now, what do you mean by recession? Recession means nothing but cancelling the. Now, recession is a word we are using for cancellation. One more word we already know. What is that word? Rescind, repudiate. All means what? Cancelling the. When two of us agree that let us not do the old contract, let us replace a new contract, that comes under novation. So let us cancel the contract, that comes under recession. That comes under recession. So let us not throw away the contract. One or two things only problematic is there. Let us do some minor alteration and continue the contract. Now that comes under alteration. Start reading. When the parties to a contract agree to rescind it, the contract need not be. In the case of recession, only the old contract is cancelled and in its place. Okay. But in case of novation, what happens? In case of the old one, new one comes into place. Next one, effect of alteration of contract. Now we already know this. I already told you. What means alteration? Minor changes are made. Yes, continue. The original contract is rescinded and it need not be performed. Stands discharged. Terms so altered by mutual agreement that the alteration may have the effect of substituting a new contract for the old one. Okay, exactly new contract is not thrown away. We are taking all the facts, important facts will continue still. Minor changes are put. Say for example, idukku novation ko enna madam difference? Novation everything can change, everything can go for change, including the parties. But in case of an alteration, I cannot change the party and all. Okay, I cannot change the subject matter. I cannot change the consideration. Maybe date change one. Okay, maybe volume change one. Okay, and maybe quality change one. So like this, place of delivery change other. இந்த மாதிரியான changes minor பண்ண முடியுமே தவிர I cannot touch the important aspects of the contract. Able to understand? Now let us go see the difference between novation and alteration. Start reading the meaning of an existing contract with the new one. In case of alteration, terms of the contract may be, next one, parties. Everyone in one single voice, please. Novation may be made by changing in the terms of the contract, or there may be a change in the contracting parties. In case of an alteration, contracting parties remain the same, only terms of contract may be altered. Yes, next one. In case of a novation, there is altogether a substitution of new contract in case of
alteration, it is not essential to substitute the new contract in place of the old contract.
We can continue the old contract with whatever minor changes we can make. Okay. Next one. Promisee may waive or remit performance of the promisee. So, promise. Who is a promisee? The person who receives the promise. Okay. Now, this promisee can remit the performance. Remit the performance now. So, you have already taken, say, 50,000 loan from me. Okay, what is your performance? You have to pay me along with the interest. Say 50,000, I am going to charge 5,000 rupees interest. Now, a few months later, you are coming and asking me or pleading me, sir, 5,000, 50,000, 5,000 or 10% interest. Not fair. So, please reduce it. This is not fair. I cannot bear it. Now, I am saying, okay, don't pay 5,000 interest, pay 2,000 rupees interest. Which means 5,000 I am discounting some amount and reducing your liability from 5,000 to 2,000. This activity of reducing the liability is called as what? Remission. Reducing the performance is called as what? Remission. Okay, let us start reading. The promisee may
Promise made to him
wholly or in part. Wholly or in part. Wholly na entire amount okay, in part abdina give me only the loan amount, no need not pay interest. You can remit, you can reduce the liability in whole or in part also, or may extend the time for such performance. All of these three items will come under what name? Remission. What is the name? Remission. So far we have seen how many terms? 4 terms. First one, novation. Novation is substituting a new contract in place of a old. Second one is means cancelling the entire contract, which means it will straight go to the dustbin. Nothing will be created from there. Straight away, no one will perform. It is discharged. There is nothing to perform more on it. That is why it is called a discharge. So third one, sir, alteration. Alteration and sir, I cannot change the entire contract. Okay, but I can make minor changes in the terms of the. Can I change the parties? No, I cannot change the parties. If you are changing parties, where it will come? It will come under. You will understand. Sir, next one, remission of the contract. Remission is the actual meaning in a reducing. Reducing what? Reducing some performance or liability. Sir, liability example. Performance ke example. Sir, I am bound to come and teach all the 7 chapters in law. Hari sir is remitting me, waiving me 3 chapters. He is asking me to come and teach only 4 chapters. These 4 chapters, come and teach, madam. 3 chapters I will remit you. He is reducing 3 chapters. Able to understand? Purida? So remission means reducing the performance or reducing the liability. Able to understand? Start reading one more time for me. Reduce the promise made to him wholly or in part, or may extend the time for such. Able to understand? Next one, very important. We already know this. Restoration of benefit under a void bill. You should not see. You'll answer whatever I ask. Okay. Now, where can a voidable contract come into picture? When the consent is not free. In what all cases consent will not be free? Coercion, alignment of other. Coercion, fraud, misrepresentation. In case of first 4 items only, the contract becomes voidable. In case contract becomes voidable, the contract because you threatened me, I was keeping myself silent. But after that, I realized no, I have the option to go to the court. Now, after going to the court gives me power, sir. You have the power to treat the contract as voidable, sir. Go choose whatever option you want to choose. Either you want to continue. If you want to keep it void, do it. Okay. Now, in this case, a voidable contract where it is converted into a void. Okay, voidable இருக்கும்போது எனக்கு ரெண்டு ஆப்ஷன் இருக்கு. ஒன்னு வேலிட்னு சொல்லி கன்டினியூ பண்றது, இல்ல வாய்டுன்னு சொல்லிட்டு கேன்சல் பண்றது. அப்படி இருக்கும் பட்சத்துல in that contract, if the opposite party has received any benefit, can he hold back the benefit or should give it back? He should restore the benefit. Where we have seen this under effects of coercion, under effects of undue influence, everywhere. In fact, all 4 items effect is same. First of all, any benefit you have received, you should restore it back. Now, are you able to understand this or? Yes. Let us go read. The party rescinding line, cancelling. Okay, rescinding means what? Cancelling. Now, in which moment exactly a voidable contract is getting cancelled? Abdina, so contract is good between A and B. Now, A is the aggrieved party. B threatened him. Threatened பண்ணி A கிட்ட இருந்து consent வாங்கி entered into the contract. Now, A is going to the court of law. Okay, court of law. Very building இருக்கும் court. Now, under this court of law, judge is saying that yes, you are aggrieved. Mr. A, you are aggrieved. Your contract is a voidable contract. Okay. Now, இன்னைக்கு தேதி என்ன? Say for example, 12th of June, this is happening அப்படின்னா, sir, 12th June, the contract is voidable. Now, A may decide after this he wants to continue or discontinue. Okay. If he wants to continue, this voidable contract will be continuing as a valid contract. He has to keep quiet, nothing more. But if at all he wants to discontinue, from this date onwards, he can treat the contract as void and cancel the contract. If the contract cancel பண்ண பட்சத்துல whatever amount A has received, he should give back to B. Whatever B has received, he should give it back to A. புரியுதா உங்க ரெண்டு பேருக்கும்? புரியுதா இருந்தீங்கன்னா எனக்கு புரியாது. நீங்க ரெஸ்பாண்ட் பண்ணாதான் I will have a confidence that yes, it has gone to your okay. இதுல ஏதாவது டவுட் இருக்கா? Doubt. So, let us start reading. The party rescinding voidable contract, if he has received
any benefit thereafter from another,
shall restore such benefits to the person from whom it was received. Understood? Clear? Okay. Now, they have given you an example. Let us go read an example. An insurance company may cancel a policy on the ground that material fact has not been disclosed. Insurance, health insurance. Okay. இப்போ எனக்கு வயசு 33 something. Now, I want to go take a health insurance. First thing what the insurance company will ask is, currently what is my health condition? எப்படி தெரியும்? எப்படி நான் கொடுக்க முடியும்? To give all reports, inner report, pressure, sugar, etc. overall body health checkup, இந்த மாதிரி எல்லாமே கொடுக்கணும். அப்படி கொடுக்கும்போது எனக்கே தெரியாம மேபி some disease could be there, or எனக்கு தெரிஞ்சு நான் மறைக்கிற விஷயமும் இருக்கும். இப்போ எனக்கு தெரிஞ்சே நான் ஏதாவது மறைக்கிறேன் அப்படின்னா, now what is that I'm doing? Actually, I'm doing some fraud activity because I know a fact and I'm concealing a fact to the opposite party. Now, who is the aggrieved party here? Insurance company is aggrieved. Can he treat the contract as voidable? Yes. Then what is involved here? Fraud is involved. Correct? Now, in this case, who has the right to cancel the contract? Insurance company has the right to cancel the contract. Yes. Let us continue. When it does so, the premium collected by it in respect of the policy reduced by the amount of expenses incurred by it in this connection must be repaid to the policy. Now, ma'am, what is that they are saying? Sir, correct, sir. நீங்க போய் சொல்லி ஒரு இன்சூரன்ஸ் வாங்கிட்டீங்க. Now, insurance premium for an entire year you are paying 50,000 rupees as a insurance premium for the year 2026. January you paid it. This is applicable for January 2026 to December 2026. Now, somewhere in the month of March, this insurance company, ICICI Health Insurance, came to know that you involved in a fraud activity, and using that fraud information, you have got this 50,000 rupees insurance plan. Abdina. What happens is, ICICI, should he repay this policy amount of 50,000 rupees? Yes, he should repay. But law enna solludu abdina, before repaying, on your behalf, ICICI would have incurred some expenses, minimal expenses. Say for example, உங்களுக்குன்னு ஒரு அக்கௌண்ட் கிரியேட் பண்ணி அந்த அக்கௌண்ட்டை மெயின்டைன் பண்ணி ஓகேவா உங்களை நீங்க ஃப்ராட்னு கண்டுபிடிக்கிற வரைக்கும் some expenses would have been made on your account. Yeah? That expenses I can reduce. Say for example, I have spent so far 3,500 for maintaining your account abdina, then after reducing that 3,500, balance 46,500 will be paid to, should be paid to me. That is what they are trying to say. Here, understood? Yes. Please give one plain reading, read for yourself and understand. Done now. Shall we go to the next one now? Okay. Now, same thing, similar is given here, but what is the difference between this one and this one? What is the difference between voidable contract and a void contract? What is the difference? Sir, voidable now, what should be there? Frequency should not be there. A contract can become void because of multiple reasons. Example, capacity to contract illana void. Able to understand. The 11 essential items contract becomes void. Change of circumstance, contract becomes void. Supervening impossibility, contract becomes void. So, multiple reasons a contract can become void in the later part of the time. Void if at all you have received any benefit, should you hold it back or give it? You should give it back. You should. Why? Because before your performance, contract became void because of so many. Okay. Do you remember all those 7 points? Sorry, 11 points. Talking about now.
Agreement, capacity for contract,
consideration, legal object, lawful consideration, not expressly declared as void. On the other side, two parties.
Fulfillment of other formalities in certain cases, certainty with meaning,
possibility of performance. January தான் நமக்கு எக்ஸாம். நம்ம ஏன் இப்போ படிக்கணும் அப்படின்னு நினைக்காது. January அப்படிங்கும் போது நீங்க இப்போதுல இருந்தே படிக்க ஆரம்பிச்சா you are a ranker. Don't you want to become a ranker? Sir. Okay. ஒரு ஆல் இந்தியா ரேங்கோட வேல்யூ என்னன்னு நமக்கு இன்னைக்கு தெரியாம இருக்கலாம். ஆனா அதை எடுத்தவங்க கிட்ட நீ போய் கேளு, அது உங்களுக்கு எவ்வளோ ஒரு பெட்டர் பொசிஷனை கொடுத்துருக்குன்னு நான் சொல்ல வேண்டாம். நீங்க உங்களுக்கு தெரிஞ்ச சர்க்கிள் யாராவது இருந்தாங்க அப்படின்னா கேட்டு. ஓகேவா? புரியுதா நான் சொல்றது உங்களுக்கு? It will be very, very helpful. I want every one of you to try for an all India rank, especially when the time is there, when the effort can be done, what not. இப்போ இருக்கு opportunity. இப்போதுல நீ ட்ரை பண்ணா you will be a rank. Okay, September I can understand, but January such a long time is there where I am promising that if syllabus is planned, இப்போ syllabus முடிச்சிட்டோம், maybe July last week, August first week உள்ள syllabus முடிஞ்சிருச்சு அப்படின்னா அங்கலேருந்து உனக்கு 4 மாசம் 5 மாசம் டைம் எக்ஸாம் ஃபேஸ் பண்ண. பொங்கல் முடிஞ்சுதான் உங்களுக்கு மோஸ்ட்லி எக்ஸாம். அப்படி இருக்கும் பட்சத்தில் why not a rank? அதுக்கு இன்னிலேருந்து எஃபர்ட். சரியா? காலேஜ் போறீங்களா ரெண்டு பேரும்? காலேஜ் போறியா? என்ன காலேஜ் போறீங்க? குவீன் மேரிஸ். மார்னிங் ஷிஃப்ட், ஈவினிங் ஷிஃப்ட்? ஈவினிங் ஷிஃப்ட். ஸோ டைம் கிடைக்கும் போது படிக்க ஆரம்பிச்சு. புரியுதா? புரிஞ்சுதா? எஸ். நெக்ஸ்ட் ஒன். Now they have given you a case study. Let us read this case study to understand better. Okay, you go home and study whatever. I will discuss this case study here now. From logical point of view, I want you to give me answer. Okay. Now, say in the month of June 2026, June 2026, I am paying a rent to, say, a godown owner. Godown owner to stock my goods. எனக்கிட்ட பிளேஸ் இல்லை, அதனால நான் ஒரு குடவுனில் போய் என்னோட குட்ஸை ஸ்டாக் பண்ணுறதுக்கு நான் ஒரு குடவுனை ரெண்ட்டுக்கு எடுக்கிறேன். யூஸ்வலி ரெண்ட் எப்படி பே பண்ணுவோம்? மந்த் ஆன் மந்த் பே பண்ணுவோம், கரெக்டாக? பட் வாட் இஸ் தட் ஐ எம் டூயிங் அப்படின்னா, ஐ எம் பேயிங் ரெண்ட் ஃபார் த என்டையர் 12 months in the first month itself. ஐ எம் சேயிங் த ரெண்ட் குடவுன் ஓனர் தட் நெக்ஸ்ட் 12 monthsக்கு என்ன டிஸ்டர்ப் பண்ணாரு, 12 monthsக்கும் சேர்த்து நான் இன்னைக்கே ரெண்ட் பே பண்ணிடுறேன். என்ஜாய். Now what happens? Okay, everything is fine. 12 lakhs, imagine 12 lakhs per month, 1 lakh is paid. June pochu, July pochu, August, October, September. September month, suddenly a fire broke in the godown. Okay. Now, fire broke abdina, the godown, adukku mele edukkume use panna mudiyum. The godown is completely shattered. Nothing could be of use. அதுக்கு மேல அதை ஃபுல்லாக ரீவேம் பண்ணால் மட்டும்தான் அந்த குடவுனை ப்ராப்பராக யூஸ் பண்ண முடியும். ஷெட்டு விட்டு எல்லா கைண்டையும் போயிடுச்சு. பட் அண்டர்ஸ்டாண்ட். Now, what happens to the rent that I have paid? First of all, this contract, whether the contract is a valid contract, in the month of June, whether it was a valid contract? Yes, June month it was a valid contract. July, August, September, was it a contract valid contract? So up to September it was valid, but in the month of September, fire broke out. Now, which means I cannot use the particular godown for rental purpose, correct? Now, what kind of impossibility is this? Initial impossibility or supervening? Supervening impossibility. Yeah, sir, after entering into a contract, because of some impossibility, the contract has become void. Able to understand? Okay, I cannot perform the contract anymore. Kandipa ida revamp பண்றதுக்கு முன்னாடி ஷெட்டா யூஸ் பண்ணது வாய்ப்பே இல்லை. So it becomes a supervening impossibility. Now, think of the rent which I gave to the godown owner. 12 months rent. Out of 12 months, how many months I have properly used the particular premises? June, July, August. 3 months. Now, should he keep all the 12 lakhs with him, or he should give me back my 9 lakh rupees? 3 months use பண்ணது 3 lakhs எடுத்து. Okay, September month la fire broke out. September month la I cannot use the particular premises. So just because the contract is went well அப்படின்றதுக்காக balance of the month, should he keep back the amount or I should give it back to me? He should restore the benefit back to me because the contract become void. In what nature? Supervening impossibility. Able to understand? Purida? So that is the example and the case study which is given here. Once you are free, go home and read it. Next one, communication of rescission. In case if you are cancelling the contract, it is very, very important that you communicate that cancellation to the opposite party. Now, the timeline to revoke a contract, timeline to cancel a proposal or offer, acceptance is all already discussed in chapter 2, unit 1. Next one, start reading. Effect of who's neglect, who's acting neglectfully? Promisee. Okay. Effect of neglect of the promisee to afford promiser reasonable facilities for. Multiple times we discussed already this. See, you are entering into a contract. See, you have a building. Okay. Full, say, 10-floor building. 10-floor building, obviously, for it to do electrical work, you need at least 1 month time, 1 month to 2 months time also எடுக்கும் because 10 floors building எல்லாத்துக்கும் 1 month. Okay. Now, after engaging into a contract, what if you are not allowing the person to enter into the building and do his job? Which means who's acting neglectfully? Promising. What is the neglect which he did? Not keeping the doors open, not allowing him to enter inside, all of this. Okay. Not giving proper instructions to the caretaker of the building to allow him. Idella yaroda neglect? Promisee neglect. Now, because of this neglect, what actually happened? Who was not given? The promisor was not given the facilities to do his performance or do his. Whom do you think is the suffering person? Promisor is the suffering person. You know, work not ready. You are not allowing me to do my work. Okay, so I am the sufferer. Now, what happens in this case? Who should be liable to pay? The promisee should be liable to pay compensation to the. Able to understand, in case of loss, in any loss that has incurred for the. Able to understand. Now, in this contract also, if at all any benefit is received, you should be able to restore the benefit. Okay, let us start reading. If any promisee neglects or fails to provide the promisor reasonable facility, what do you think by reasonable facility? Any requirement, sir. Example, நீங்க வந்து டீச் பண்ணுவோம் அப்படின்னா மினிமம் செட்டப் என்ன இருக்கணும் சார்? லைட்டாவது இருக்கணும். ஓகே, ப்ரொஜெக்டர் எல்லாம் போர்டு வச்சு கூட எடுத்துக்கலாம். கரெக்டா? மினிமம் என்ன இருக்கணும்? லைட்டாவது இருக்கணும். லைட் கூட இல்லாம நான் குழந்தைங்க வச்சு எங்க இருந்து? Okay. Now, say for example, if the class is crowded, okay, people are suffocating அப்படின்னா மினிமம் என்ன இருக்கணும்? ஃபேன் ஆன் இருக்கணும். But understand, இது ரெண்டுமே இல்லை அப்படின்னா you are not providing me any reasonable facility to conduct the class. Here, understood? It's continued. Reasonable facilities for performance. The promisor is excused from non-performance caused by the student. Now, there's an example that is given here. Starting. If an apprentice refuses to learn, the teacher cannot be held liable for not teaching. Now, this apprentice is the promisee. Okay. And this teacher is the promisor. Now, this teacher is ready to teach. Accept பண்ண வேண்டியது யாரு? Apprentice. Correct? Now உட்காந்துட்டே இருப்பேன், கவனிக்கவே மாட்டேன்னா you will என்ன சொல்றது? Will you blame the teacher? No, you cannot blame the teacher because the teacher, her job is good, but the learner, his mentality was not right. Okay, he was not in a mindset to listen to the teacher. You cannot blame on the. Able to understand? அப்போ இந்த இடத்துல சார் நீங்க சொன்னதே எனக்கு புரியல, நான் கொடுத்த காசை திருப்பி கொடுங்க அப்படின்னு கேட்டா, whether that can be taken as a charge, you cannot take it as a. Able to understand? Clear? Yes. So this repair example is similar to what example which I gave you in case of a building and electric. I'll give you a few minutes time. Go through this small area and come. 5 minutes. 5 minutes. Please go through. We killed a PDF. வந்து தரேன்னு சொன்னாங்க, மருந்து தரேன்னு தெரியும். இனிமேல் ஊருக்கு போவியா? யாரா ஒருத்தர் போங்க, நீங்க தந்தாதான் உள்ள போவேன்னு சொல்லு. வாங்கிட்டீங்களா வெறுச்சு எல்லாருமே கிடைச்சிச்சா daily 2 or 3 questions ஓகேவா ரேங்க் ஓகே 50 ரேங்க் இருக்கு அதுதான் ஒரு ரேங்க் தான் உங்களுக்கு கேக்கு ஓகே உன்னை கேட்கலன்னு தப்பா நினைச்சுக்கோங்க இப்போ செப்டம்பர்ல தூங்குறதே பெரிய விஷயம் சரியா இருக்கிற ஹெல்த் கண்டிஷன் மேனேஜ் பண்ணிட்டு பாஸ் பண்ணா போதும் அவ்வளவுதான் போதும் அவ்வளவு மோசமா பர்ஃபார்ம் பண்ண மாட்டேன் மோசம் சொல்ல முடியாது பட் ஐ presume you will decently perform 230 220 Yes, let us go to the next area, discharge of a contract. Now, what do you mean by discharge already? We know there is nothing more to perform in case of a discharge of contract. Now, in what all ways a contract can get discharged? Okay, not all ways a contract may be discharged. First one, sir, contract la enna performance irukko and the performance na mudichittana the contract is discharged. ஏன்னா அதுக்கு மேல அத பண்ண வேண்டியது ஒண்ணும் கிடையாது. So first one enna discharged by performance. Meaning what is the meaning of that? The contract is already performed. If I already performed, there's nothing more to perform and the contract becomes discharged. Nothing more to do from each other. Okay, start reading. When the parties to a contract fulfill their obligations under the contract within the time in the manner prescribed, discharged by performance, actual performance or attempted performance. Now, actual performance na enna neenga rendu per varla but actual performance you are actually performing it, job is done, you are done, tested alla mudichittu galami poite irukku. Attempted performance na I was ready to come and perform at your place. Okay, you do not allow me to perform. Okay, this is called as what? Attempted performance. Meaning you came forward and attempted to give your performance. The opposite party did not allow you to perform. So even in that case also, later on he cannot come and charge against you. Yeah, 1 minute. Let me come. Now, say for example, today I contracted to come and take the class. The classroom door is shut. Students are varla, yarume varla. But I came and I was waiting for the student, faculty, management, everyone to come and open the door and get the class running. Now, for example, today for handling today's class, I was awarded or I was contracted for say 5,000 rupees for handling today's class. Abdina, this contract is valid only for today. Now, can tomorrow Hari sir come and charge against me? Yeah, madam, neenga varla naalik vandu kekka mudiyadhu. Ena contract was for today and I came here and was ready to give my performance. I attempted my performance. You did not take it. Mistake is on your end. Tomorrow you cannot come and file a case. The contract stands discharged. Understood? Clear? Doubts?
The neglect of
Same. Okay. Now it was whose neglect? Promisee's neglect. Yeah. Promiser was very good to come and give his. Okay. So in both the cases, what happens? It is a discharge of. What are the both cases? Actual performance, attempted performance. No, attempted performance only. I was correct. The other party was wrong. Okay. Because he was neglectful, because he did not allow me to do the performance, why should I suffer? Okay. I am correct. So, next one, the same thing is repeated. Next one, discharge by mutual agreement. Now, this is what we have already seen in the previous topic. In what all cases both the parties come together and decide, let us not perform the contract. First one, novation, cessation, alteration, remission. What are they agreeing to in first case? Let us substitute the new contract. Second one, let us cancel the contract. Third one, let us include minor changes to the existing contract. Remission, no? Let us reduce the liability of. Now, this can happen only if both the parties are mutually agreed. Okay? So, in case of this mutual agreement, obviously what happens? The contract gets discharged. Discharged by mutual agreement. Start reading.
If the parties to a contract agree to substitute a contract,
It is novation or to rescind it or remit it or alter it. Now, remit na enna appadina remission oda remission they are using another term, that is remission. சரியா remission க்கு இன்னொரு வார்த்தை என்ன? Now, alter it, the original contract need not be performed. Okay, wow. Next one, discharge by impossibility of. What is impossibility? We already know. Inside the contract itself, there could be two types of impossibility. One is initial impossibility. Abdina enna? At the time of contract itself, I know you know it is not possible. Okay, then that kind of impossibility is called as initial impossibility. At the initial point of time itself, it is impossible. Supervening abdina, at the time of making the contract, everything was valid. Okay, it is a valid contract. But later on, because of some external happenings, okay, contract has become impossible to perform. That kind of impossibility is supervening impossibility. Okay, wow. Now, what and all could be the situations are some unforeseen change in law or destruction of the subject matter. Example, sir, I was about to sell my car. Sir, car I are திருடிட்டு போயிடுச்சு. Okay, திருடிட்டு போன காரை நான் தேடி கண்டுபிடிச்சு விற்கிறதுக்குள்ள I don't know when it will happen. Okay, declaration of any war. Now, there could be some nations in which we may be at war. Sudden or war on the ship, all contracts between this country, that country is totally stopped. Okay, starting the impossibility may be ab initio, nothing but initial impossibility, or it may supervene. Supervening impossibility may take place only to
unforeseen change in law, the destruction of the subject,
the declaration of. Okay. Next one, discharge by lapse of time. So what do you mean by lapse of time? Whatever time period is given, time is over. Okay. Usually, any contract will have a timeline. Timeline illa appadina reasonable time should be taken. If you are not acting within the timeline, or where time is not there, if you are not acting within the reasonable timeline, then the contract is discharged because of lapse of time. Let us start reading. Contract, if it is not performed and if no action is taken by the promisee within the specified period of limitation, usually 3 years, it becomes unenforceable. Now, what is that they are trying to say is, sir, if a person is not performing within the time period mentioned in the contract, or where time period is not mentioned within reasonable time, then what you should have done? You should have filed a case. So, usually a person can file a case within 3 years. For 3 years, you file after 3 years, the contract becomes unenforceable. Okay, after 3 years, what happens? Contract becomes unenforceable. Meaning what? You cannot file a case on against the opposite. You have to keep quiet. No other. Start reading the example for this. File a suit against the buyer for the recovery of the price within 3 years. Debt becomes time bar and hence irrevocable. அதுக்கப்புறம் நான் ஃபைல் பண்றேன் அப்படின்னா first of all ஃபைலே எடுத்துக்க மாட்டேன். You will understand. Next one, because of operation of law. Now the law says this contract cannot be done. Okay, say for example, at the time of entering into a contract, I was a very good person, sane person. I can think on my own, I can work on my own, I can take decisions on my own. Something happened, that person collapsed abdina, then that person becomes a insane person. Can an insane person be asked for performance? No, because he does not have the capacity to contract later point of time. Okay, even at that point also the contract will stand discharge. நீ சேல் இருந்தா இன்சேனா இருந்தா perform பண்ணி தான் அப்படின்னு சொல்ல முடியாது, because the law says you cannot insist performance from a insane person. Insane person. Next one, discharged by breach of contract. Now, the term breach means what? Breaking what? Breaking the rules. Okay. Why did you breach? Why did you break the rule? Okay. Breach of contract. You are not performing the contract. So, இன்னைக்கு perform பண்ணோம், இன்னைக்கு நான் ரெடி, நீங்க ரெடியா இல்ல, you are keeping the closed doors அப்படினா, first it is neglect. Second, you are breaching whatever you committed. So you committed me a payment of 5,000 today, correct? Okay, I have to come and take class. You will have to give me 5,000 rupees end of the day abdina. You have committed that you will pay me 5,000 rupees today. Now, varadinga door shut panting abdina, first thing neglect. Okay, second thing, you are breaching the contract by not paying me. Clear? Understood this? Start reading. Breach of contract may be or stop. Actual breach means, sir, today is the performance due. Any performance due? Inniki na kaalla phone panni sonna, sir, I cannot. Then this is called as what? Actual breach. Actual breach. Inniki da performance due. Inniki morning na call panni ennala vara mudiyadhu, na idha panni thara maata, I cannot do this job for you. Contract cancel பண்ணிடலாம் இப்படிலாம் சொல்றேன் அப்படின்னா, it is called as what? Actual breach. So anticipatory breach அப்படின்னா, performance is next week. Okay, performance எப்போ? Next week. ஆனா நான் என்ன பண்ணேன்னா, இந்த வீக்கே கால் பண்ணி சொல்லிடுறேன், சார் நான் இந்த வீக்கெண்ட் வந்து லண்டன் போயிட்டு ரிட்டர்ன் ஆகிறதுக்கு 2 months ஆகும், so I cannot perform the contract அப்படின்னா, sir, I'm anticipating a breach. That is why it is called as anticipatory breach. Okay. So actual breach na enigma performance due on that day. Anticipating na when is the performance due? Sometime later, for which you are calling up and informing today itself that I am not performing the. Okay. Yes, continue. If one party defaults in performing his part of the contract on the due date, it is called as actual breach. Whereas before the stipulated time for its performance has arrived, he is deemed to have committed anticipatory breach. Able to understand what I told you? Next one, promisee may waive or remit performance of promise. Now, this point and the earlier point which we saw in earlier topic, discharge either. Okay. Effect of novation, other list last second item, this one and the remission point same, wherein two parties can agree and the promisee can remit the performance. Next one, this is also same. Effect of neglect of promisee to afford reasonable facilities for performance. In both the cases, what happens? Contract gets discharged. Last one. So void could be because of multiple reasons, and that void will ultimately culminate into what? Discharge. Okay, void is we decide, but on the void enga poi kadasila mudiyona contract discharge and no one is about to perform the. Next one. First, another step number 1 ஏறதுக்கு step number 2 போகுது. Step number 1 will be void. And ultimately it will lead to discharge of. Okay, இது இல்லனா அதுன்னு சொல்ல முடியாது. void இருக்கும் பட்சத்துல it will next step go into discharge. Next one, merger of rights. Now this is a crucial item, very interesting item. So today we are sitting in a rented home. Now, tenant, what rights you have inside that home?
Make whatever
you want, you can make
without having.
without damaging the property. As a tenant, you can just occupy it. அதாவது உங்களோட பொருள் எல்லாத்தையும் எடுத்துட்டு வந்து ஸ்டோர் பண்ணிக்கலாம். அதுக்கப்புறம் நீங்க வீடை யூஸ் பண்ணிக்கலாம். In case for that matter, if you want to insert a nail, tap a nail also, you have to take permission from the house owner. Okay, as long as you remain as a tenant. But imagine you are getting the same house now as a lesser. So far you are paying a monthly rent. The moment you take the particular premises on lease, you are paying a lease for a particular number of years. Now, compared to a tenant, when you become a lessee, do you think you have a higher rights or lesser rights? You may have more rights. Okay. Now, compare your situation if you become the owner. அதே வீட்டில் டெனண்டாக இருக்கீங்க, அதுக்கப்புறம் அதே வீட்டில் லெஸ்ஸராக வரீங்க, லீஸ்க்கு எடுக்கிறீங்க அந்த வீடு. சே ஃபார் எக்ஸாம்பிள் 3 years. அந்த 3 years முடியறதுக்குள்ளேயே அந்த வீடே சொந்தமாக வாங்கிடுறீங்க. You will enjoy all the rights, which means whenever your position is going to change within that same subject, okay, obviously your inferior rights will get merged with the superior rights. As an inferior right, tenant right to occupy the place. The moment you become the owner, you can do whatever alteration you want in the house plus occupy the house. So this is called as merger of rights, where your inferior rights is getting merged with the superior. Okay, let us start reading. Superior rights coincide and meet in one and the same person. In our example, who was that one and the same person? Ourselves. Okay, நான் அந்த வீட்டில் வாடகை இருக்கேன், நானே அந்த வீட்டை சொந்தமாக வாங்குறேன் அப்படின்னா, in both the transaction, who's that one single person? It's myself, isn't it? So my inferior right as a tenant is now getting merged with the superior right as a now the moment I become the continuity. In such cases, the inferior rights merge into the superior rights. On merger, the inferior rights vanish and are not required to be enforced. Okay, the moment I become the owner, what happens to the rental contract which we made? Obviously, it goes to the dustbin. Okay, see, imagine where the situation is. 2026 January, you were a tenant. Okay, 2026 say November, you are becoming the owner of the place. Abdina, sir, idukana rental agreement, it is there up to December. Even before you become even before this contract is getting over, you become the new owner. Abdina, in the contract value in the contract rental agreement value because the inferior right is getting merged with the superior. Clear? Understood? Okay, wow. So that is with respect to discharge of contract. I'll give you a few minutes time. Please go through the last two topics. 10 minutes time. 5 minutes for this and 5 minutes for the early. Discharge of contract alone, I want you to study and write. Okay, will you write now? Study discharge of contract and write. Need not give any example. Only just two lines are there under each area. Please study and write. Take 10 minutes time. 11:15, you should have completed writing. Possible, huh? Clear. Say 10 minutes for studying and 10 minutes for writing. 11:30 வரைக்கும் டைம் எடுத்து ஓகே படிச்சு எழுதி முடிச்சிடணும். Take another 10 minutes break and come. இதுக்கு நடுவில் நான் சீக்கிரமா எழுதி சீக்கிரமா முடிச்சுட்டு நிறைய பிரேக் எடுக்கிறேன் your choice. But 11 11:40 you should have completed. Come back after break. 11:40. I've started writing. Done. Check your answer. Restart writing. Restart writing mode. ரைட்டிங் ஸ்பீட் இம்ப்ரூவ் பண்ணுங்க. Yes, have you done last 2 points? Write fast. Start check. or take a break and come. Now both of you done. Last one point. Niruma. 7 to 8 minutes. Reasonable. Yes, take a break and come back. We'll start with this new unit and complete it for today. Come back by 10:45, 11:45. Go, take a break and come. We have to start one more chapter. Meeting by check. Check if Hari sir has come and take this notes, hand notes for this chapter. Print money kuduksu. Kudutara. ஐசர் வந்தாருமா இருக்காரு.
I thought it was the question related to minors, but on age when the 21%.
Shall I take it after the class?
Yes, sir.
Let it be with me and seconds. Let me mark the test exam. 50 marks.
1 and 2 mainly questions were assigned. Bloody limbo. So 1 A B எழுதணும் and 2 A B எழுதணும் 3 எழுதணும் 30 marks.
இது வந்து ஆக்சுவலி இது உங்களுக்கு கொஸ்டின் பேப்பரில் தான் ஆக்சுவல் கொஸ்டின் பேப்பர் எக்ஸாக்டாக இதோட ஆன்சர் என்னன்னு உங்களுக்கு கொஸ்டின் பேப்பர் சரியா
ஆனால் அந்த
வில்
கொஸ்டின்
டிஸ்கஸ் வில் டிஸ்கஸ்
அது கொஸ்டின் ஆஃப் மைனஸ் எழுதணும்.
மைனர் ஆனால் மைனர் வராது
மைனர்
வில் டிஸ்கஸ் வில் என்டர் வில் டிஸ்கஸ் என்டர் வில் டிஸ்கஸ் Officers come. That idea. Ask police. Got it. Someone call Harrison. Already. Hello? Call edited. Okay, don't waste time. Go study novation. All those 4 items. Novation. Please prepare novation, remission, recession, and alteration. Very simple. Hello? இந்த ப்ரொஜெக்டர் ஆன் ஆகல இந்த மூவி ஆன் டேப்லெட்டும் வரல சரி
ஆச்சுன்னா போயிடும்.
எதுல காட்டுச்சு?
இந்த ஒயர் நான் தள்ளி வச்சுட்டேன்.
Yes, let us start with this new chapter, breach of contract and its remedies. Now, what is breach of contract? We already know. Breach of contract means you are not performing on the contract. Now, under breach, we already knew few things about breaches. What are the two types of breach? Breach of contract. Now, what is breach of contract? We already know. Breach of contract means you are not performing. We already
Class exam one.
in about two types of breach. I don't get any class.
இல்ல வருதா?
Check. Hello. Check. Check.
உங்களுக்கு கேக்குதா கேக்குது? ரோஹித் ஆக்சன்.
ரோஹிதாக்ஷ் கேக்குதப்பா? அவங்க சொல்லுவாங்க.
பேசுங்க.
இப்போ பேசுங்க ரோஹிதாக்ஷ். ஓகே.
பேசுனா ஒவ்வொன்றா சொல்றேன்.
அவங்க சேர்ந்தாங்க ஹாப்பி ஆயிடும். So we already knew what are the types of breach. What are two types? One actual breach, another anticipatory breach. Actual breach now. Performance is already due. On the day you say I cannot come and perform. This is actual. Anticipatory now. Performance is due somewhere in the future or sometime later. And now itself you are saying that you will not perform the contract. Yes, start reading. Breach means what? Breach means perform is our obligation under the contract, which means you are failing to perform as per the contract. And we know already what are the two types, one actual and another anticipatory. Now, this anticipatory is either expressly or impliedly understood. One expressly means by words spoken or written, impliedly by the conduct of one of the parties. How will I know impliedly? Sir, I am bound to come and take classes. Okay. Now, instead of me coming here and taking classes, I already booked my tickets to say Goa, Pondicherry, Kodaikanal, weather get the money, you will understand now. Which means I've already made myself prepared for planning a weekend, planning a trip. But how can I come and take class? Able to understand? Which means by my conduct, I am showing that I am not ready to come and take or I am not ready to come and do the. Able to understand? Clear? Sir, business example. Sir, I have some product A, some product B. Okay, I'm about to sell that product to you. This was the contract made. But when even before, actually, before I come and perform, I sold the entire lot to another person. அப்படின்னா என்ன அர்த்தம்னா உங்களுக்கு சேல் பண்றதுக்கு என்கிட்ட ஒண்ணுமே இல்லைன்னு அர்த்தம். Which means impliedly I am showing what I cannot perform the. Now question may come to ma'am, time இருக்கு அவருக்கு perform பண்றதுக்குள்ள இந்த பர்சன் இன்னொரு வாட்டி மேனுஃபேக்சரிங் யூனிட் ரன் பண்ணி ப்ராடக்ட்டை ஸ்டாக் பண்ணால வெல் குட், நோ ப்ராப்ளம் அட் ஆல். ஓகே, ஆன் தட் டே இஃப் யூ ஆர் டூயிங் தட் அப்படின்னா நாட் அ ப்ராப்ளம். ஆன் தட் டே the stock is ready, you are able to go and perform, then not a problem at all, not an issue. Yeah, but say for that matter நீங்க மேனுஃபேக்சரிங் ஆரம்பிச்சு இந்த மேனுஃபேக்சரிங் வந்து finished யூனிட்டா கன்வெர்ட் ஆகிறதுக்கு say it takes 2 months time, then obviously until 2 months you will not be able to give the product. It implies that within the next 2 months performance is not. So obviously what happens, it comes to be a anticipatory breach of. Maybe if the contract itself is 3 months away abdina, then we have to wait and see. Okay, we cannot conclude that it is a anticipatory breach. Start reading anticipatory breach. Is a breach of contract occurring before the time fixed for performance. When the promisor refuses altogether to perform his promise and signifies even before the time as right, it is called anticipatory breach, and it is of two types. What? Express and implied. Now, effect of anticipatory breach. So, first effect, what is the first default? No, what will happen? Ultimately, what is the solution? First is to cancel the contract and sue the party for damages. What is the first treatment, ma? You can cancel the contract and sue the party for damages. Okay. Example. Sir, I am bound to deliver my goods in the month of July 2026. Today we are standing only in June month. Obviously, if I call today and say I cannot deliver my goods abina, then this falls under actual or anticipatory breach. Now, what here happens is, say if suppose the party who is engaged is A and party C who is engaged is B abina, A is the seller and B is the buyer. Now, who is the affected party? Buyer is the affected party. எனக்கு குடுக்குறேன்னு சொல்லிட்டீங்க, அவர் எதிர்பார்த்துட்டு இருப்பாரு, இப்போ கால் பண்ணி முடியாதுன்னு சொல்லிட்டீங்க. Now, how he is affected?
He does not have the product.
He is not having the product, but product வரதுக்கு actual due is only July month. Problem actually என்ன அப்படின்னா, he has to start searching for another new vendor in that particular quality, in that particular price, in that particular quantity. Able to understand? All this is going to take time. All that is going to take effort for him. Correct? Now, particularly in this case, in the buyer, two options. The law is giving two options. First option enna abdina, sir, treat it as cancelled. Okay, and file a case against it. Treat it as cancelled and file a case against it for taking damages. Second, please sit and wait. Please sit and wait. Wait until what time? Until July 2026. Sir, avan June மாசமே பண்ண முடியாதுன்னு சொல்லிட்டாரே sir. Sir, law is giving another opportunity to the seller. Maybe July kulla if he is performing, what is the problem? யாருக்கு எந்த பிரச்சனையும் இல்லையா? So, law says one can treat it as cancel and file a case. Second, wait until July month. July actual due date of performance வரைக்கும் wait பண்ணு. அன்னைக்கு வரைக்கும் அவன் performance பண்ணல அப்படின்னா, then on that day file a case against him and whatever is the procedure, continue with the litigation. Okay. In between this time, okay, ஜூன்ல இருந்து ஜூலை போறதுக்கு now 60 days are there. Entire June is there, entire July end is there. Now within that 60 days, if at all a supervening impossibility occurs, abdina it in whose favor it will work? The seller's favor it will. Now who's the seller? Promisor or promisee? Promisor. Promisor's favor la it will. Okay, let us start reading. What is the first step? To treat the contract as rescinded and sue the other party for damages from breach of contract without waiting until the due date of. Appo, when will this treatment happen? In the month of June or July? This will happen in the month of June. Appo, June month itself, you can cancel the contract and file a case for recovery of damages. If not, or what is the second option? Start reading. Not to rescind and do not cancel the contract, but treat the contract as still operative. Meaning in a still operative. Meaning in a it is still valid, and wait for the time of performance, and then hold the other party responsible for the consequence of non-performance when? In the month of July 2026. The party who has defaulted can also take the advantage of supervening impossibility, which may have the effect of. Okay, இது by default இந்த பெனிஃபிட் கிடைக்குது. ஏன்னா ஜூலை மாசம் வரைக்கும் வெயிட் பண்ணும்போது திடீர்னு ஜூலைல ஒரு பெரிய ஃப்ளட் வரலாம். The contract becomes impossible to perform. அப்போ அந்த impossibilityயால becomes the situation becomes favorable in the hands of whom? Okay, so that is with respect to anticipatory breach. Next one, actual breach. Already we know what is actual breach. In case of refusal to perform on the fixed date, scheduled date, performance due date, all of this means the same. Continue reading. When breaks the contract by refusing to perform his promise, he is said to have committed a breach. In that case, the contract obtains the right of action against the one who has refused to perform. Now, what kind of action we can take, ma? We can sue him. Okay. Now, continue. Examples for this. When you have time at home, read. Next one, this is important for us to read and remember. Remedies for breach of contract. First of all, see what are the remedies. First remedy is sue for damages. Now, second remedy, come down, you will find. Second remedy, rescission of the contract, meaning cancellation of the contract. Next one, quantum merit. Quantum merit, abdina, sir, so far whatever you are performed, for that I am ready to pay amount. For that, you should be in a position to recover the amount. Okay. Now, this is quantum merit. And then suit for specific performance, suit for injunction. So, totally how many remedies they have given us? 4 plus 1, 5 remedies. First remedy in damages. Second remedy in rescission of the contract. Adutha quantum merit, and then suit for specific performance, suit for injunction. One more time, repeat with me. First one, damage. Second one, rescission, quantum merit, suit for specific performance, injunction, suit for injunction. Now, come to the first item, suit for damages. Now, start reading. Under damages, we have different varieties or different categories of damage. Let us see one by one. But before that, start reading. Suit for damages.
Each of the contract,
The party who suffers from such a breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him by breach. No compensation is payable for any remote or indirect. Okay. Now, which means you should have directly suffered a loss. Example, sir, on belief that you will give me products, I would have promised a different contract with a different person. அப்போ நீங்க எனக்கு டைமுக்கு டெலிவர் பண்ணனா நான் அந்த பர்சனுக்கு டைமுக்கு டெலிவர் பண்ண முடியாது. Charge a fine on me. In turn, that is a direct loss because of your default. That I will take it from you only. You will understand. Okay, sir. நீங்க சொன்ன டேட்ல பெர்ஃபார்மன்ஸ் பண்ணல. Because of you, I have to pay bank interest. That also I will directly charge from you only. You will understand. So all these are direct loss. Indirect loss abdina, sir, I have promised another person that I will deliver, but I have not given any data. Okay, எனக்கு டைரக்டா உங்களால எதுவும் லாஸ் கிடையாது அப்படின்னா simply you're charging because of this cancellation or because of his non-performance. If you're simply charging any amount, that cannot be taken as a direct. You will understand. Direct loss na உங்ககிட்ட யாராவது ரிகவர் பண்றாங்க அதனால நீங்க லாஸ் ஃபேஸ் பண்றீங்க அதெல்லாம் வந்து எங்க இருந்து வரும் டைரக்ட் லாஸ். You will understand. If you are not directly suffering any loss, then it comes under indirect loss. Now there is no measure that there should be an indirect loss. Say for example, I have contracted with you to purchase at say 50 rupees per kg. Okay, நீங்க டிஸ்கவுண்ட் பண்ணுங்க or you are not performing the contract. நீங்க பெர்ஃபார்ம் பண்ணாதனால நான் இன்னைக்கு போயிட்டு வேற வெண்டரை தேடுறேன். வேற வெண்டர் he is charging me 55 rupees. 5 rupees extra than you. Now in the 5 rupees extra, should I charge from you or should I put from my own pocket? I should charge from you only. Yeah, abdina, because of you I am suffering extra 5 rupees loss. Sir, no. நீங்க உங்க பெர்ஃபார்மன்ஸ் கரெக்ட்டா பண்ணிருந்தீங்க அப்படினா why should I go search for another person? Okay, நீங்க இல்லன்னு சொன்னா அப்ப இன்னொருத்தர் அவர் 55 க்கு தான் தருவேன்னு சொல்லுங்க. It is because of you purely that I am facing this extra 5 rupees. Clear? Understood? Shall we go to the categories under damage? First one is ordinary damage. Start reading. The party who suffers by such breach is entitled to receive compensation for any loss or damage caused to him, which naturally arose in the usual course of such cases. Now, whatever example I told you now, isn't it? All of that will be a damage or a loss that naturally arose in the usual course of breach. Such compensation is not to be given for any remote or indirect damage. Now, let us see an example which is given here. This is a case study. First item is a case study and second one is a example. Let us finish the example first and come back to the case study. Mr. A agrees to sell Mr. B bags of rice at 5,000 per bag, which means rupees 5,000 per bag. Delivery to be given after 2 months. On the date of delivery, the price of rice goes up to rupees 5,500 per bag. Mr. A refuses to deliver the bags to B. B can claim A rupees 500 as ordinary damages arising directly from breach of. Okay. Now there's another example. Case study here. Let us start reading the case study. Slowly read, very slowly, word by word. This exact case study came as a case study based question. அதனால பொறுமையா மைண்ட்ல வச்சுட்டு படி. The crankshaft of P's floor mill had broken. Crankshaft is nothing but kind of a machinery. Okay, it has broken. He gives it to D, a common carrier, who promised to deliver it to the foundry in 2 days, where the new shaft was to be made. So contract was between whom and whom? Mr. P and Mr. D. Let us keep name Priya and Divya. Okay. Now, who has contracted for what? Priya is supposed to give some money. Okay. And for this, Divya will transport the particular machinery in how many days? 2 days. This is the contract. Now, what happens is Divya delayed the delivery of the crankshaft So the mill remained idle for another 5 days. Now, why does the mill has to remain idle for another 5 days apart from the idle time which was already pre-planned? Because of the delay of Divya. Priya received the repaired crankshaft 7 days later than he would have otherwise received. Consequently, Priya sued Divya for damages not only for the delay in delivering the broken part, but also for the loss of profits suffered by the mill for not having worked during the idle days. The court held that, the court gave a judgment that P was entitled only to ordinary damages and D was not liable for the loss of profits because the only information given to D was that article to be carried was the broken shaft of the mill and was that the delay would result in loss of. Now, in this same case study, we can study two types of damages. One ordinary damages, another special damages. Now, why this person cannot claim money, Odina? If your intention was to cut off any delay, then you should put it inside the contract. It's a delay panni, and the delay naala machine otama enakku profit loss aachu. Then that profit loss also should be compensated by you. That is a special clause and that damage is special damage. Okay. In your contract, you have not mentioned that in case of delay, you will have to face profit loss. Abdi mention panna the pakshatla, it will become an indirect loss. Indirect loss compensation. Indirect loss compensation, you will receive only ordinary damage because of the 2-day delays. Understood? But if at all in the contract, if at all you have mentioned, sir, actual delivery you should make on say 15th of June. You should have made the delivery on 15th of June. In case you 15th kulla deliver panla abdina, then I cannot work on a big project. Can't work on big project. Say, and the machine the machine run panni or project panna. Say, suppose government kitchen or peri order okay, or a peri function and the function where say everyone who attends that have to give some rice. Okay, say rice flour I should give. Or minimum 5 kgs rice flour or 5,000 people were attend. Imagine the volume of rice flour I would require, isn't it? Appo in the machine illana enala the contract edukka mudiyum. Correct? Appo 15th kulla machine enak kadaikiradhu very crucial. So if at all I want to charge a special damage, I should mention inside the contract that if at all I am not receiving on 15th of June, then I will incur a profit loss because I will not able to perform the government order, and the loss you only should compensate. If at all you have mentioned that, then that damage is called as special damage, and it is known to the party also. Carrier also, transport பண்றவங்க நீங்க அதை inform பண்ணிட்டீங்க. Therefore, he will be able to pay. He should be paying the ordinary damage as well as the special damage. So, okay, yes. Let us go read special damage. Receives a notice of special circumstances. Now, okay, in our example, what was the special circumstance which I told you? The government order which we received. Okay. Now, 15th June kulla enak and machine திரும்பி கிடைச்சா மட்டும் தான் என்னால அந்த government order fulfill பண்ண முடியும். அப்போ அந்த government order in case நான் fulfill பண்ண முடியல because of your delay, you surely should take responsibility. Means you are letting the transport person know about your special circumstance and the damage that is attached to it. In that case, you can recover the special damage. So now they have given you same case study with the extra information, which is the government contract. The same example is what I told you. Okay. You can go home and read. Next one, vindictive or exemplary damage. Now, this kind of damage is only applicable in two cases. First case is in case of breach of promise to marriage. Second case, in case of dishonor because of the banker. Now, in both cases, a person's credibility is lost. A person's trust is lost. கரெக்டா நான் இல்லையா சி கல்யாணம் ஒருத்தருக்கு ஃபிக்ஸ் பண்றாங்க ஃபிக்ஸ் பண்ணி லாஸ்ட் மொமெண்ட்ல தட் த கேர்ள் ஆர் த பாய் தே ஆர் வாக்கிங் அவே அப்படின்னா வாட் ஹேப்பன் டு த அதர் பர்சன் ஹூஸ் லெஃப்ட் பிஹைண்ட் இஸ் broken. Okay, the trust, the confidence that person had on you is broken, isn't it? Appo for that a person can charge. Which person? The affected person can charge vindictive or exemplary damages. Next one, in case of a wrongful dishonor of a banker of his customer's check because it leads to loss of credit. So, for a business person, check bounce is very crucial, very critical because it impacts the business. How it impacts? Credibility. ஓகே அவன் எவ்வளோ தூரம் அந்த பர்சன் ட்ரஸ்ட் வர்த்தி அப்படின்றது எனக்கு எப்படி தெரியும்னா அவர் கொடுக்குற செக் வந்து ப்ராப்பராக கிளியர் ஆச்சுன்னா மட்டும்தான் ஐ வில் பிலீவ் தட் பர்சன். ஓகே, ஒருவேளை அவர் கொடுக்குற செக் 2 வாட்டி பவுன்ஸ் ஆச்சு அப்படின்னா வில் ஐ கண்டினியூ மை பிஸ்னஸ் வித் ஹிம்? நோ, ஐ வில் நாட் ஹேவ் ட்ரஸ்ட் ஆன் ஹிம். அப்போ அந்த பர்டிகுலர் பர்சனுக்கு if the bank has done any dishonor and that too because of some wrong handling or mishandling, then who should be the affected party? Business person. Now, who's affecting it or whose activity is affecting the businessman? Banker. So this business person can very well charge a vindictive or a exemplary damage from the bank. Okay, and the bank should be giving such a damage amount or compensation amount to the business person. If suppose I am not a business person, will this work for me? I am not a business person. If I am not a business person, then why should be there a என்ன சொல்றது அவ்வளோ இம்பார்ட்டன்ஸ் என்னோட ட்ரஸ்ட்டுக்கும் என்னோட கிரெடிபிலிட்டிக்கும் இருக்கணுமோ தேவையான்னு கேட்டீங்கன்னா தேவையில்லை. சே ஃபார் எக்ஸாம்பிள் ஐ எம் ஜஸ்ட் அ ஹோம் மேக்கர். சே ஃபார் எக்ஸாம்பிள் ஐ எம் ஜஸ்ட் அ ஸ்டூடெண்ட். சே ஃபார் எக்ஸாம்பிள் ஐ எம் ஜஸ்ட் அ எம்ப்ளாயி. அப்படின்னா இன்கேஸ் என்னோட செக் தவறுதலா பவுன்ஸ் ஆச்சுன்னா இட் இஸ் நாட் கோயிங் டு இம்பாக்ட் எனி அதர் பர்சன். அண்ட் பிகாஸ் ஆஃப் தட் ஐ எம் நாட் கோயிங் டு ஃபேஸ் எனி ஹியூஜ் கிரெடிபிலிட்டி லாஸ். ஓகே, அப்போ அந்த ஹோம் மேக்கருக்கோ அந்த ஸ்டூடெண்ட்டுக்கோ அந்த எம்ப்ளாயிக்கோ செக் பவுன்ஸ் ஆகுது, அதுவும் தவறுதலா பவுன்ஸ் ஆச்சு அப்படின்னா then that person cannot claim any damages from the bank. So this is a very peculiar case that is applicable only for a person who does business, and because of that business activity, if at all there is any dishonor of check from the fault of the banker, he can charge for any vindictive damages. Understood? Few minutes time, please go through the last 3 items. Okay, next one, nominal damages. Now, from the word we can understand that the damage that is charged is very nominal in nature. Nominal and very least number. The value of it is not more. The value of it is very minute. Okay, wow. Now, why will someone charge a minor amount, small amount? Reason is he wants to establish that so and so has defaulted. அதை எஸ்டாப்ளிஷ் பண்ணுறதுக்காக இஸ் சார்ஜிங் அப்படி எஸ்டாப்ளிஷ் பண்ணி என்ன மேடம் ஆக போகுது? இன் ரியாலிட்டி தேர் இஸ் நோ லாஜிக் அட் ஆல். அந்த 10 ரூபா நீங்க வந்து டேமேஜா வாங்கிட்டு வாங்காம இருக்கு. அண்டர்ஸ்டாண்ட், பட் ஸ்டில் ஹி வாண்ட்ஸ் டு எஸ்டாப்ளிஷ் தட் so and so other person has not performed the contract as he promised. He is trying to establish by going through a court. Start reading. Nominal damages are awarded just to publish the right to decree, and right to enforce for the breach of contract, but he has not in fact suffered any real damage. The amount, the penalty amount maybe it could be a rupee or even 10 paise, very minute. Okay, but my only intention is to take you to the court of law, which means enforce and prove that you have did. Next one, important. Deterioration, damages for deterioration caused by delay. So, say for example, you are supposed to deliver me some goods. It could be perishable goods, it could be non-perishable goods. If it is a perishable goods, what is the maximum timeline that you can delay? Maximum 4 to 5 days according to the type of the perishable goods. If you are delaying the goods more than or beyond 4 to 5 days, what happens? Will I take it at the same cost, same price, or I will pay lesser amount? I will pay lesser amount. Able to understand? Now, whatever damage that has happened, whatever deterioration in the quality, I will reduce the amount and make the payment, or I will make full payment as per the contract and I will charge you damage in the name of what? Damages for deterioration. Okay, option number 1, instead of paying 100 rupees per kg, because you caused so much delay, I will pay now only 50 rupees. Option number 2, I will pay 100 rupees full stitch as per the contract and I will take damages in the name of deterioration, damages caused because of deterioration. This is perishable goods. In case non-perishable goods, what happens? What could be the maximum reasonable time in case of non-perishable goods? It can easily go up to months also. But in case of a non-perishable good, what happens, Abdina? Every now and then, the technology is getting updated. The non-perishable goods can become obsolete. Obsolete na unusable. See, if I have two iPhones, okay. One is from 2013 model, one is from 2023 model. Which will you opt for? 2023. Yeah, Abdina, 2013 has become outdated, means obsolete. Correct? Will it have the same sale value or the sale value will become lower? It will become low. Other damage and I will take it from you. Able to understand? So, in the mouse, this is the latest mouse. The light okay. This is 4-5 மாசம் போச்சுனா இதே protonics வேற different colors, bright colors are red color, yellow color, green color, neon colors. People will go for that neon colors or still stick on to this black color. They will go to neon colors. Brighter. Okay, young generation like bright colors, isn't it? If you are delaying me for delivery of this mouse for 3 months, 4 months and all, obviously, the demand in the market will reduce. Demand reduce, price will reduce. Price reduce, my profit will also reduce. My selling will also reduce. My sales activity itself will reduce. அப்படியும் போய் நான் சேல் பண்ணா கூட I have to sell it at a very low price. So no, there are high chances that it will remain in the godown itself. யாருமே வாங்கவே மாட்டான். கரெக்ட்டா? அப்ப அந்த loss will happen because of whom? Because of your delay. Able to understand? This also I can charge it as a damage in the name of damages because of deterioration caused by. Understood? So let us start reading. In the case of cost damages can be recovered even without a notice. Now, idhil eppadi madam case study based question kettam. Now, case will be given. Case study based question will be given. Inside that one small line, but notice was not given. Can he recover the damage? First of all, can the damage is the damage possible? And if at all damage is possible, okay, damage is realizable, can he recover the amount? Okay, is a notice required for this அப்படின்னு மூணு சப்டிவிஷன்ல கேள்வி வரும். அப்போ first of all you should go and explain this is a damage and what type of damage, and damage because of deterioration caused to delay, and under this category the law requires no notice, therefore damage is recoverable அப்படின்னு ஆன்சர் எழுதுது. புரிஞ்சுதா? So even if it is a small word, still it has so much importance. Yes. So in two cases we require notice so far whatever we have seen. What is the first case? Special damage, where special circumstance பத்தி நீங்க கான்ட்ராக்ட்ல சொல்லிருக்கணும். Second one, even without notice, damage caused because of deterioration caused by delay can be recoverable. So special damage we need notice, and for this we need not even give notice. Continue reading. The word deterioration not only implies physical damages to the goods, but it also needs special opportunity for sale. Special opportunity for sale. Next one, prefixed damages. Now, from the very word itself, we can understand that the damage is already prefixed. It will be prefixed inside the contract itself. Say, within 15th of June, if you are not coming and delivering, I will charge you 2% as damages. Which means it is already prefixed inside the contract itself. Okay? And அது எவ்வளவு value அப்படின்றத fix பண்ணிருக்காங்க. 2% of the entire contract. இதுக்கு முன்னாடி also mention பண்ணிருக்காங்க அப்படின்னா, sir, இதுக்கு முன்னாடி whatever is the performance breach that has happened, and because of that performance breach உங்களுக்கு actual loss என்னவோ அந்த actual loss தான் you are able to recover. கரெக்டா? ஆனா இந்த prefixல அப்படி கிடையாது. The moment you breach the contract, automatically how much the person is supposed to pay, whatever 2% or 10% or which is mentioned in the contract, that much you will end up paying. Now, in this prefix damage, there are two types. One is asking for liquidated damage and charging penalty. You need to understand what is the difference between liquidated damage and penalty. So, liquidated damage, it is a probable estimate. In case இவங்க இந்த டைம்குள்ள டெலிவர் பண்ணலன்னா தோராயமா எனக்கு இதுல ஒரு 10% லாஸ் ஆயிடும் அப்படின்னு நீங்க சொன்னீங்க அப்படின்னா you are expecting a probable loss that you may incur. But what about penalty? Penalty in the very term says it is hefty. Penalty is put so that you will not commit that mistake. Penalty, fine, இதுக்கு எல்லாத்துக்கும் ஒரே டெண்டன்சி தான் இருக்கு. என்ன டெண்டன்சி? அந்த மிஸ்டேக்கை நீங்க ரிப்பீட் பண்ண மாட்டீங்க. ஸ்கூல்ல என்ன பண்ணுவாங்க? ஷூ பாலிஷ் பண்ணலன்னா ஃபைன் போடுவாங்க, பெனால்ட்டி போடுவாங்க, 50 rupees, 100 rupees, so that next time you will not repeat that mistake. அப்போ in case of a penalty, it is always having only one thing in mind, என்ன? Not to repeat the mistake. It will push you to follow the rules. It will push you to follow the rules. அப்போ இந்த இடத்துல நீங்க அப்ளை பண்ணும்போது what it does அப்படின்னா it pushes you to commit whatever, perform whatever you have committed. புரியுதா? நான் சொல்றது புரிஞ்சுதா? அப்படியே பார்த்துட்டே இருந்தேன். Are you listening to me? Let us start reading. Parties to a contract slowly, very slowly. Stipulate at the time of its formation that by any of them a certain amount will be payable as. So this amount is already put when? At the time of formation itself. Formation of what? Formation of the contract. It may amount to either liquidated damages, meaning and liquidated damage to reasonable estimate of likely loss in case of breach, or a penalty. What is a penalty? An amount arbitrarily fixed as damages. Now, why it is arbitrarily means, sir, defend பண்றதுக்காக I put that amount. Say contract value itself 50,000 rupees. Penalty போட்டு 20,000 rupees போட்டு. Reasonable இல்லை. ஆனா ஏன் அப்படி போடுறேன் அப்படின்னா so that you will perform as per your commitment. Okay. See, 20,000 penalty pay பண்றதுக்கு நான் 50,000 ப்ராப்பர்ட்டி கொடுத்துட்டு போயிடுவேன். But understand, it is stopping you from reaching the, so that breach பண்ணலான்ற thought process கூட உங்களுக்கு வரும். அதுதான் ஒரே intention of charging the. So English நால இந்த பெனால்ட்டிக்கும் லிக்விடேட்டட் டேமேஜஸ்க்கும் நிறைய டிஃப்ரென்சஸ் இருக்குது. ஓகேவா? இந்தியன் லால பெரிய டிஃப்ரென்ஸ்லாம் எதுவுமே கிடையாது. பட் ஃபார் த பர்பஸ் ஆஃப் த கான்ட்ராக்ட் ஆக்ட் தே ஆர் ஷோயிங் தட் லிக்விடேட்டட் டேமேஜ்னா இது பெனால்ட்டினா இப்படி இருக்கும் அப்படின்றது தான். அப்போ பேசிக் டிஃப்ரென்ஸ் என்ன மேடம்? சார், liquidated damage is something that you expect that you may face a loss if at all breach happens. But liquidated damages abdina, it is penalizing in nature, it is punishing in nature. Okay, 50,000 ரூபாய் contract 20,000 ரூபாய் penalty na, obviously it is threatening, it is punishing, penalizing. So it has the character of penalizing. Yeah. Let us go see the difference between liquidated damages and penalty. I want you to give a plain reading. You should be able to understand. Yes, I want you to read this. Read this tabular column and as well as this 4 points. Read for yourself and understand. I'll give you 5 minutes time. It's in very simple, plain English. Please read. Inachu. While going, take a different printout from Hari's. Okay. Mathi staple panda. Don't know. Yes. என்னம்மா? இல்ல கேக்கல, சரியா கேக்கலாமா? எங்கடா இருக்கு? Can you put it in the WhatsApp group? Mobile கூட எடுத்துட்டு வரணும். Third point, fixation. இதுவா? கீழே third point இங்க இருக்க அதுவா? டிக் பண்ணிருக்கேன் அதுவா? ஓ, இது கேக்குறியா? டெரரம்க்கு மீனிங் என்னன்னு கேக்குறியா? Terrorism means it is causing a fear. See, 50,000 contract with 20,000 rupees penalty. Don't you think it is causing a tremor inside us? It is causing a fear inside us. So penal charges are always causing terror inside a other person, so that he will not commit the breach. He will not do any breach of the contract. You're done. Let us move to the next table. Done now, Ulama. Okay, other remedies. The first remedy is rescission of contract. Already we know what is rescission. Cancel breach pandra abdina. Obviously, we can cancel and sue the person. Sue for what? Sue for damages. What kind of damages? If at all you incurred any loss because of this breach, you can claim that as compensation and for any damages if he has suffered because of the other person. Okay. Next one, quantum merit. Now, this is very multiple case study based questions. Quantum merit abhina, as much as I have performed, as much as I have performed. Say for example, today all 4-5 of you go and inform Harish, sir, now madam, ask her to go. You told her update kekra Harish. You're asking me to stop coming for class. Okay. Okay, இல்ல சரி இன்கேஸ் ஓகே மேம் நீங்க எடுக்கிறதே புரியல மேம் என்ன நீங்க சொல்லி தரீங்க அந்த மாதிரி நீங்க போயிட்டு ஹரி சார் கிட்ட கம்ப்ளைண்ட் பண்றீங்க ஹரி சார் சேஸ் ஸ்டாப் கமிங் ஃப்ரம் டுமாரோ நீட் நாட் கம் நீங்க இது வரைக்கும் பண்ணதே போதும் அப்படின்னு சொல்லி அமைச்சிட்டாருன்னு வச்சுக்கோங்க இது வரைக்கும் நான் ஒரு 10 கிளாஸ் எடுத்துருப்பேன்னா அந்த 10 கிளாஸ்க்கு அவர் பேமெண்ட் தரணுமா தரணும் ரீசன் ஏன் அப்படின்னா as much I have worked, he should compensate me for as much that I have worked for. Even though the contract is for 3 months, okay. Even though up to exams I should assist you, but if at all, if there's a breach of contract, because he only asked me to stop coming, he's breaching the contract. But I have performed. Okay, 10 classes have gone so far. For the 10 classes. As much as I have performed, he should compensate me. Ma'am, 3 months ago, we have discussed a payment of say 50,000 rupees. About 3 months to 50,000 rupees now. Last 15 days only we have come. Last 15 days, like so much amount of dinner. We should come to some judgment and he should give me a payment. Understood? Clear for everyone? If suppose, say the payment is on hourly basis. Madam, per hour I am ready to pay 500 rupees abdina. So far, how many hours I have taken? Directly into 500 and he can pay me. If per hour is not mentioned, only 3 months basis, like completion of target, he is supposed to pay 50,000 abdina. Whatever number of days I have come, or how much ever part of the syllabus that I have completed, as much percentage into 50,000 rupees, he will give me only. Understood? Clear? Shall we go read? Quantum merit, meaning as much as the party doing the service has deserved. So how much do I deserve? Last 10 classes payment I deserved. Okay. In case of party suffering the breach, had at the time of breach done some part of the work or performance under the contract and seeks to be compensated for the value of work done. Okay. Tell me in the party mention panniranga. Let us take both of our names. Okay. Harison and myself. As much of the party now. Who's this party here? Myself. Okay. Has served. In case of party suffering the breach, yes, this party is also myself. Had at the time of breach done. Who does the breach? Hari sir does the breach. Done part of the work or performance under the contract and seeks to be compensated for the work. See the example, interesting example they are there. Start reading. Orders only 12 bottles of whiskey. Man, na podla example. ECI podla example. Don't misunderstand me. Now, 12 bottles of whiskey from a wine merchant, but also receives 2 bottles of brandy, and the purchaser accepts that. The purchaser must pay reasonable price for the. இது எப்படி தெரியுமா ஹோட்டலில் ஜொமேட்டோவில் போட்டுருங்க 2 பொங்கல் ஆர்டர் பண்ணி கூட 2 வடை சேர்த்து போட்டுருங்க அண்டர்ஸ்டாண்ட். அப்போது யூஸ்வலி நம்ம என்ன பண்ணுவோம் வடையை சாப்பிட்டு கவர்மெண்ட் எடுத்துருவோம். லா என்ன சொல்லுது அப்படின்னா இஃப் யூ ஆர் ரிசீவிங் எனிதிங் எக்ஸ்ட்ரா For that extra also you should pay some amount. எக்ஸாக்டா திருப்பி போய் Zomatoல கம்ப்ளைண்ட் ரைஸ் பண்ணி எக்ஸாக்டா வடையோட பிரைஸ் 50 ரூபாய் பே பண்ணணும். Some amount you should be able to pay. அதுதான் யார் சொல்றா? Yeah, that is quantum merit. Now claim for quantum merit. In the quantum merit எந்தெந்த situationsல நீங்க பார்க்கலாம். All of these situations you can see quantum merit. Let us go read one by one and understand. Where an agreement is discovered to be void and when a contract becomes, sir, when I made the agreement, that time I have already performed something or contract was valid, later on it became void, supervening impossibility. அப்போ எவ்வளோ வரைக்கும் நான் பர்ஃபார்ம் பண்ணிருக்கணும், அது ப்ளீஸ் கிவ் மீ அமௌண்ட். You will understand. Contract was made for, say, delivering, say, 1000 kgs of rice. And it has to be transported from India to Pakistan. Valid contract. But all of a sudden, the policy got changed. Now we are stopping all border transactions. How much ever I have sent so far, say 1000 kg, or 200 kgs, the 200 kgs I will receive. Able to understand clear? Next one, when something is done without an intention to do so gratuitously. Freely. Sir, I have done something, but my intention is not to do freely. அப்படின்னா நீங்க எக்ஸாக்டா எம்ஆர்பி கொடுக்கணும் அவசியம், நீங்க எக்ஸாக்டா சர்வீஸ் காஸ்ட் கொடுக்கணும் அவசியம். Pay something. Able to understand? Previously, when we used to attend classes and all, as a promotion purpose, no, they will take one very big hall and they will give free class for 5 days crash course, 2 days crash course, free crash. On the last day, the faculty will say, today also I am grateful for that, but the faculty will say, உங்களுக்கா தோணி நீங்க ஏதாவது பே பண்ணணும்னா பே பண்ணுங்கன்னு சொல்லி ஒரு குண்டி வச்சு. Course is free, okay, but later point of time, okay, if at all I want to do it, I don't want to do it freely. As a Guru Dakshina, pay 1 rupee also, that is also enough. Everyone will contribute and from that contribution, the faculty will take it. Okay, 1 rupee is equal to free of cost. Yeah, so whatever you feel so, you can pay because I don't want to give it free. Education should be not gracious because you are free எடுத்துக்கிறது உங்களுக்கு அவ்வளோ பலனை கொடுக்காதுன்னு சொல்லி லாங் டைம்லேருந்து அந்த கல்ச்சர் இருக்கு. ஸோ பிகாஸ் ஆஃப் தட் ரீசன் ஐ வாண்ட் டு சார்ஜ் சம் மணி அண்ட் வாண்ட் டு கிவ் தட் எக்ஸாக்ட் அமௌண்ட் வாட் எவர் யூ ஃபீல் லைக் யூ கேன் கான்ட்ரிபியூட். ஹியர் ஆல்சோ ஆஸ் மச் ஆஸ் ஹீ இஸ் ஏர்ன்ட் அப்படின்னும் போது சார் அவரோ பெரிய எக்ஸ்பர்ட், ஹீ இஸ் ஆஸ்கிங் மணி ஷுட் ஐ பே 5000 10,000 அப்படிலாம் இல்லை. வாட் எவர் யூ திங்க் ரீசனபிள் யூ கேன் பே. ஓகே, next one, express or implied contract to render services but there is no agreement as to remuneration. Sir, immediately இதெல்லாம் எங்க நடக்கும்னா in case of after you become chartered accountant, you want to file, you would be filing all this income tax return. Your friend comes and knocks the door, your relatives comes and knocks the door. Now in here what happens is the moment they come and start giving you their documents, you will file all the returns. illa file பண்ணுவோம், எல்லாம் ஃபைல் பண்ணுறீங்க. அவங்க அப்பாவுக்கு அம்மாவுக்கு ஒய்ஃபுக்கு சில்ட்ரனுக்கு எல்லாருக்கும் ஃபைல் பண்ணுறீங்க, முடிச்சுருவீங்க. நான் முடிச்சதுக்கப்புறம் முடிக்கிற வரைக்கும் கூட யூ ஹவ் ஆல்சோ நாட் ஆஸ்க் இவ்வளோ ஃபீஸ் எனக்கு வேணும். ஹீ ஆல்சோ நெவர் ஆஃபர்ட், சார் உங்களுக்கு எவ்வளோ வேணும், நான் எவ்வளோ பே பண்ணணும், நெவர் ஆஃபர்ட். Now ultimately you are doing some performance even without discussing the remuneration. But finally, if all the work is over, one fine day, what actually happens is avarka thoni ennava pay pandrona adha you mind about. Able to understand? So here also what comes into picture? Quantum merit comes into picture, where there is no contract, nothing discussed, never, but work is done, and for that work done, whatever they feel that is reasonable, they will give you and you will accept it. Next one, one party abandons or refuses to perform. Okay, obviously the other party will become the suffering party. He will ask for compensation or he will ask for remuneration of whatever he has. இது எப்பனா between the contract or in the middle of the contract, the other party is withdrawing. Next one, where a contract is divisible and the party not in default has enjoyed the benefit of part performance. So, where a contract is divisible, say you are buying 1000 kgs of rice. Do you think the contract is divisible or indivisible? It is divisible. Why? Because 1000 kgs is just a number. 1000 can be broke into two halves. 1000 can be broke into three parts. 1000 can be broke into multiple segments. Correct? அப்போ எவ்வளவு தூரம் டெலிவரி பண்ணிருக்கணும் அவ்வளவு தூரம் you can take money. Able to understand? That is what they are trying to say. So when the contract is divisible and where the party who is not in default has enjoyed the benefit of part performance, he should pay for the part performance. Next one, where the contract is indivisible for a lump sum money and is completely performed but badly performed. See, let me give you an example. Building a house, is it a divisible contract or indivisible contract? Divisible contract or indivisible contract? Building a house, I'm not talking about this multiple multiple house flats மாதிரி பேசுறேன். நீங்க உங்களுக்காக ஒரு வீடு கட்டுறீங்க, 2 floor டூப்ளெக்ஸ் கட்டுறீங்க உங்க பர்பஸ்க்காக. டிவிசிபிள் இன்டிவிசிபிள் ஒரே கான்ட்ராக்ட் பண்ணி ஒரு வீடை கட்ட முடியும். level 1 ஒரு கான்ட்ராக்ட், level 2 ஒரு கான்ட்ராக்டா போட முடியும். இன்டிவிசிபிள். Now you have given this to a building constructor. He started raising the building. Complete பண்ணி முடிச்சதுக்கு அப்புறம் தான் தெரியுது he is using the quality of cement, all the raw materials are not of good value, good quality. எல்லாம் second hand quality தான் யூஸ் பண்ணிட்டு இருக்காரு. Now he has completed the performance. Completed வீடு கட்டி முடிச்சாச்சு. He has done it in a bad manner. How do you say it is a bad manner? By checking the report and all, you can definitely see the bills and all which he is showing second quality வாங்கிருக்காரு. அப்போ performance is done but in a bad manner. So will you pay the full contract amount or you will reduce the amount? What you have to see. Let us go. Read very slowly. Lump sum for a lump sum money is completely performed. The bill. It is completely performed. Okay, but badly na some quality defect. The person who has performed the contract can claim the lump sum, but the other party can make a deduction for the. Who can make the deduction? The house owner can make the deduction. If at all, I have to take it for a business example of Dina. So, have you delivered the 1000 kgs of rice? Yes, sir. So, after cross-checking, I find that this quality of the rice is not as that I ordered. Will I pay you still 1000 rupees per kg? No, I will pay only 800 rupees. Able to understand? So, the opposite person may ask for 1000 rupees. Sir, listen, do another, sir. Ignore them. Able to understand? That is what they are saying the last point. Chariya? Last 2 items, please stick on. Last few minutes, please stick on. Suit for specific performance and suit for injunction. Now, suit for specific performance means, see, நீங்க எவ்வளவுதான் டேமேஜ் கொடுத்தாலும் எனக்கு அந்த டேமேஜ் வந்து செப்பரேட் ஆகும். Okay, say you are planning to attend A.R. Rahman sir's concert. Concert na என்ன தெரியும்ல? One night they will take a very huge place. They will sing songs and you will celebrate. All of that is there. Okay. It is specifically whose concert? A.R. Rahman sir. Now, do you think A.R. Rahman sir will conduct the concert on his own, booking the place, putting all the light fitting settings? No. There's actually a entertainment or a production house separately. That's business. அவங்க என்ன பண்ணுவாங்கன்னா ஒவ்வொரு இடத்துல எந்த இடத்துல போடலான்றத செக் பண்ணி எங்க போடலான்றத பார்த்து அந்த பர்டிகுலர் டேட்ல சீஃப் அந்த பர்டிகுலர் ஆர்டிஸ்டோட டேட்ஸ் வாங்கி ஒரு டேட் அனௌன்ஸ் பண்ணி கொலாப் மாதிரி போட்டு அதுக்கப்புறம் அந்த அந்த பர்டிகுலர் ஆர்டிஸ்டோட ஃபேஸை வச்சு தே புல் பீப்புள். நீங்க எங்கேயாவது சோஃபார் ஏஆர் ரஹ்மான் சார் வந்து பேசி பார்த்துருக்கீங்களா? கிடையாது. ஏஆர் ரஹ்மான் சார்னு போஸ்டர் மட்டும் தான் பார்த்துருப்பீங்க. அதுக்கு லிங்க்ல போய் பேமெண்ட் பண்ணியிருப்பீங்க. இந்த பேமெண்டோட பில்ல பார்த்தீங்கன்னா வேற ஏதோ கம்பெனியோட பேர் இருக்கு. பிகாஸ் தட் இஸ் ஜஸ்ட் அ என்டர்டெயின்மெண்ட் ஹவுஸோட ப்ரொடக்ஷன் ஹவுஸ். Now they will put this particular full event into picture, and for that event who should be the main person? Because Seeing him only, you paid the amount 1,500, 2,000 rupees, 10,000 rupees, like that. Say for example, on that particular day, sir did not come. What will happen? We will feel cheated. No, who will feel cheated? You people. Now, next time if that production house conducts any event, will you go join? No, you will not join. அப்போ இந்த இடத்துல ARMN sir comes and says, I will pay crores of damage. அப்படினாலும் அந்த damage amount, அந்த money, will it equal it? Will it equate for that loss? It will not equate. Okay. So அந்த இடத்துல what is my only option is filing a case against so and so artist, so that even though you give damage, that will not equal my loss. You please come and perform. This is called as what? Specific performance. Okay, you give damage, you have to come and perform. That is my only solution, because lakhs of people are there ready only to see you, your voice, hear your voice, listen to your song. அப்போ அந்த இடத்துல நான் ஏஆர் சாரோட மியூசிக்கை ப்ளே பண்ணுறேன், அவரோட டூப் ரெடி பண்ணுறேன் அப்படின்னா, okay, start reading. When damages adequate remedy. See, listen. He is ready to pay damages, but still it is not a proper remedy. Okay. In that case of breach of contract, the court may at its discretion. Discretion now meaning at his choice. At its choice. Court order choice. Direct the party at breach for specific performance to carry out his promise according to the terms of the contract. According to the terms of the contract. Now, somewhere in Unit 1, we came across, not in Unit 1, Unit 3, we came across this specific point. So, minor court cannot come up with this kind of order. Okay, minor in the court order for asking specific performance will not apply at all. Okay, wow. And after all, he is a minor, and minor can always plead his minority. Next one, suit for injunction. Injunction means to stop. Injunction means what? To stop. So, in the court, stay order nu சொல்வாங்க. கேள்விப்பட்டிருக்கீங்களா? Stay order na என்ன? எது எப்படி இருக்கோ அதை அப்படியே ஸ்டாப் பண்ணும். நிறைய பேர் இந்த சிவில்ல தான் இது நிறைய கேள்விப்பட்டிருக்கேன். பில்டிங் ரேஸ் பண்ணிட்டே இருப்பாங்க. இந்த பில்டிங்னால என்விரான்மெண்ட்டுக்கு ஏதாவது ஒரு ப்ராப்ளம் வந்துடும், அப்படியே ஸ்டே ஆர்டர் வாங்கும், அந்த பில்டிங் அப்படியே நின்றுடும். ஓகே, இது அதுக்கு மட்டும்தான் ஒர்க் ஆகும்னு சொல்ல முடியாது. நார்மல் பிஸ்னஸ் கான்ட்ராக்ட்ஸ்லேயும் ஒர்க் ஆகும். நிறைய இந்த சினிமாஸ்ல தான் ஒர்க் ஆகும். ஏன்னா யூஸ்வலி when a very big hero, take in case of very big hero, where they are committed to one single project at a one point of time. Okay, yeah, அப்படின்னா usually these kind of production houses, they don't want to reveal the outward appearance for that character. இது ரீசெண்டாக கூட நிறைய இந்த ஜனநாயகம் போஸ்டர் கூட வெளியே விடாம ரொம்ப போஸ்டர் ஸ்டில்லாம் எதுவுமே வெளியவே விடாம மெயின்டைன் பண்ணாங்கன்னா படம் ரிலீஸ் ஆகலன்னு சொல்லி. ரீசன் என்ன அப்படின்னா, they were trying to protect the identity of that particular character inside the movie. எப்படி இருக்கும்னு ஒரு எல்லாருக்குமே இருக்கும் இல்லையா, ஒரு கியூரியாசிட்டி இருக்கும் இல்லையா, அந்த கியூரியாசிட்டி இருக்க வரைக்கும் தான் அந்த மூவி செல் ஆகும். தட் இஸ் த ஒன்லி ரீசன் they will hide all this kind of appearance. அப்படி இருக்கும் பட்சத்துல, see, I am paying hefty money for that also. எப்படின்னா, see, from January 2026 to June 2026, you should be only working with me. Okay, I am ready to pay extra money also. You should not work with any other production house, any other director, no other film. Abdina, for that 6 months, you are mine. Okay, your time belongs to me. Your effort belongs to me. You cannot work any other project. Yeah. If at all you are accepting any project, will I keep quiet? So what will I do? I will go file a case against you. I will file case file பண்ணா மட்டும் இந்த இடத்துல ப்ராப்ளம் சால்வ் ஆகுது அப்படின்னா, கேன்சல் பண்ணிட்டு போறதுக்கு மூவி அப்படி பண்ண முடியாது. சே 500 crores இன்வால்வ். ஓகே, விஜய், சே அஜித், அந்த மாதிரி ஒரு ஃபேஸ் இருக்கனால மட்டும்தான் ஐ எம் இன்வெஸ்டிங் 500 crores inside. But just like that, if I file a case for cancelling the contract, will it suffice? No. In this place, what kind of case I will file? I will file a case for injunction, stay in a state, not to enter into any other project or movie. Okay, I will ask you to stay or stop your other project. Clear. Let us go read. Where a party to a contract is party to a contract does not follow the terms of a contract, the court may, by issuing an injunction order, restrain him from doing what he promised not to do. Yes, this particular actor promised that he will not participate in any other movie or he will not act in any other movie. But our பாட்டில் நடிக்க ஆரம்பிச்சிட்டார். No, what will I do? I will go file a case and take a injunction order. Injunction order வந்ததுக்கு அப்புறம் என்ன பண்றேன் நான்? I'm restricting him. I'm stopping him from going and participating in another. Able to understand? Clear? If at all say I have a know of a particular item. Say for example, இப்போ இந்த டெக்னாலஜி இப்போ இதை முன்னாடியே பார்த்துருக்கீங்களா? இந்த மாதிரி ஒரு போர்டில் உட்காந்து இதை பெண் வச்சு இது உங்களுக்கு புதுசு கரெக்டா? ஆனால் இது மார்க்கெட்டில் வந்து எத்தனையோ வருஷம் ஆச்சு. இது வந்த புதுசில் திஸ் என்டையர் ஐடியா இட்செல்ஃப் is in only one single person's mind. அக்ரியா? கரெக்டா? இதை யாரும் ஒருத்தர் ஃபர்ஸ்ட் யோசிச்சிருப்பாங்க. இந்த மாதிரி டிஜிட்டலா நம்ம பென்ல எழுதி நம்மளோட ஹேண்ட் ரைட்டிங்லேயே நம்மளால எழுத முடிஞ்சா எவ்வளோ நல்லா இருக்கும்னு ஒருத்தர் யோசிச்சிருப்பாங்க. Which means this is altogether something very new business idea, isn't it? அப்போ இது பண்றதுக்கான காசு இருக்கு சார். ஓகே, ஐடியா இருக்கும், காசு இருக்கு. அப்போ இதை அப்ரோச் பண்றதுக்கு யார்கிட்ட போவோம்? ஒரு இன்வெஸ்டர் கிட்ட. Now this investor is ready to invest in you, but provided you take proper patent of this idea and stick with this investor for the next 10 years. Next 10 years. அப்படின்னா என்ன அர்த்தம்னா, this investor will invest in your idea and enter into the manufacturing of this product. Patented product. Patented product na உங்களை தவிர வேற யாரும் பண்ண முடியும். Able to understand? நீங்க யாருக்கு ரைட்ஸ் கொடுக்குறீங்களோ அவங்கள தவிர வேற யாரும் மேனுஃபேக்சர் பண்ண முடியும். அப்படின்னா after entering into such a contract, if you go see another investor, he is also manufacturing the same kind of item அப்படின்னா, then what can this person do? Earlier first manufacturer, he can stop, he can take an injunction order and he can stop you entering into contract with a new manufacturer. Able to understand? புரியுதா நான் சொல்றது? உங்க ரெண்டு பேருக்கு please go to last one. But today's homework will be this damages fully you will study. Okay, all types of damage you will study and you will go review Vividsu chapter 1 unit 3. Okay, all case study based question. At least try to write 2 case study based questions. Okay, so you prepare and write on your own 2 case study based questions from chapter 2 unit 3, and then you will also study and write this damage types of damage. Okay, so that is with respect to today's class. Yes, we'll break the class today. Thank you so much. வரலையா? புக் பேக்ல இருக்க கொஸ்டின்ஸ் ட்ரை. ஓகே. And next class we will also discuss your question paper issue.